soon listing.
Ooh.
I know, I'm pretty excited. It's next week. So what we're going to do today, people, is we're going to spend a little time talking about what's going on. I'm going to rant today because I got something I'm really not happy about. And then we'll try to save the last 20 minutes or so for questions and answers. So if you've got a question, just type it on in, and Cody and Stephanie are monitoring it. And if it's a question of broad general interest, we'll go live with it. If it's a question that Cody or Stephanie can answer, they'll be happy to do it. So Stephanie, why don't you say hello to everybody and tell them what's going on with the association, and then I'll jump in, and then Cody can follow up. He's got some stuff he wants to talk about too.
Sounds great. Hello, everybody. Happy Monday. Can you believe it? We're like dead in the center of summer. Feels like anyways, at least at my house. Thank you for joining us today for John's Rants. I am beyond pleased to be asked back to be a guest. So here we are. As a reminder, if you guys have questions, put them in the Q&A. We're not really monitoring the chat box. So get those questions into Q&A, and Cody and I are going to be monitoring those. Just a couple updates from the association. Governor Newsom made a big, Governor, that's a new name. Governor Newsom just made.
It's nicer than the name I've been calling him.
Yeah, for sure.
He just made recently this morning an announcement. So stay tuned for more information from PWR on if that's going to have an effect on our industry. But keep in mind with that. And then just a quick save the date, Tuesday, August 11th. I'm getting text messages saying the same thing, John, that people have names for him. But Tuesday, August 11th at 10 a.m., we are going live with the new DRE commissioner. So that's going to be great. He's going to be covering all sorts of stuff, hot topics, what's going on, how the DRE has upped their staffing to kind of cover, and they've moved over into a COVID task force. So that's Tuesday, August 11th from 10 to 11. That's going to be a great one. So you'll get a ton of information before that happens, but I just wanted to make sure you guys could save the date with that. And that's my update, John.
Okay. Yeah, we'll keep you guys posted about, we're not sure exactly how we're going to do that from a legal standpoint, but again, because the governor just went on, and not to be perfectly honest, I didn't see his newscast, so we'll keep you guys posted. What I want to do today, though, is I've got a couple of topics I'm going to throw on the table, and then, of course, we'll answer any questions that might come up. But I want to tell you guys about three bills, generally speaking. Now, understand that the legislature is on a 2-week hiatus, which is, again, my way of thinking is great news for California, because what they're doing, and again, I guess since this is my rant, I'm going to rant in a second about one of the three bills, which I think is absolute insanity. One bill is AB 828, and it's again a bill that continues the moratorium on landlord-tenant evictions and things like that. It's in a lot of ways duplicative of another bill, which I'm going to rant about, which is AB 1436. But before I do that, I want to tell you about another bill that's pending, and it is still alive, and that is AB 1703. With this bill, some of you might remember a couple of rants ago I mentioned to you, or maybe it was one of our panel programs that I mentioned to you guys, that up in San Francisco, they have an ordinance that before you can sell a residential rental, you've got to first offer it to your tenant, and then if the tenant is not willing to purchase it, you've got to offer it to one of the approved nonprofits. And if they aren't willing to buy it, then you can put it on the market, and of course now you're down 30, 45 days. Then you can sell it, but when you get an offer, before the offer can go into escrow, you've got to first offer it back to those same groups and give them an opportunity to match whatever it is that you were offered for the property. The process could delay the ability to sell your house, your rental property, for up to 8 months. 1703 would make that a statewide program. Now, there are some distinctions, and it doesn't cover every piece of residential rental property, but it's clearly going to hurt mom and pops. 1436 is a bill that has been amended now 7 times, including as recently as July 2nd. It is sitting in the Senate Judiciary Committee right now. Now, here's where we're going to rant. So Stephanie's off the hook, Codi's off the hook, the board's off the hook. This is my opinion of this bill. I've been exchanging correspondence with Christine, who is your GAD, phenomenally intelligent woman, along with the GADs from a couple of other associations. This bill is insanity. What it does is it prevents a landlord from collecting rent on past due rents for a period that will be either a certain period of time after this emergency is lifted, which of course he just reinstituted a bunch of stuff. So the idea that it's going to be lifted anytime soon, I think is wrong. Or April 21st, April of 21, whichever comes sooner. So sometime in April, and of course, it'll give the governor the right to extend that out even further. You won't be able to collect rent or evict people, and it doesn't have anything to do necessarily with COVID. All the tenant has to do is provide an unverified letter, whereas the landlord, in order to go forward, will have to sign a declaration of opinion of perjury. So why am I so unhappy with this bill? Well, number one, it offers absolutely no protection for a landlord. So let's say Codi buys himself a rental, generate a little passive income, pays $2,000 a month in a mortgage payment, rents the place out for $3,000 a month, and now what does he have? He has a $2,000 a month payment or a foreclosure with absolutely no protection on the other side, other than possibly being able to get some tax credits. But again, if you don't have the cash to pay your mortgage, a tax credit isn't going to do you much good. There's absolutely no protection for the landlords whatsoever. So who's that going to hit the most? Mom and pops, right? Those people that have invested in real estate with the idea that they would generate some passive supplemental income for themselves during their retirement or even during their working years to put money away for down the road. There is absolutely no incentive given for investment, for building, or for anything else. And what it will do is it will, in my opinion, negatively impact the entire market in that manner. Some of you might recall Stephanie and Codi, probably not you guys. I think they stopped teaching the Constitution back in my day. But there used to be this thing called the Constitution of the United States of America. And what that did is it said the government can't come in and just seize property without due process of law. And so what they're doing, in my opinion, is circumventing that Constitution, which the government was supposed to be limited. And clearly, the people up in Sacramento no longer believe that they have any limitations on what they can do. My opinion, not the board's. So it impairs the right to contract. If those of you that actually remember your civics classes, the Constitution gives people protection to sign contracts with each other so long as they're legally made, so long as the parties have the capacity, so long as the parties are doing something for not an illegal purpose, you're free to contract. And now the government's stepping in and saying, we're going to take the side of one party to that contract to the detriment of the other, and we're going to impair the right to contract. Again, in talking to some of the GADs and in talking to others, Codi, I know you and I have had this conversation. Stephanie, we have not. But it's government without balance. Because if they clearly, we don't want an uptick in homelessness. We don't want people out on the street. There are legitimate reasons why people have not been able to pay their mortgage. I don't think anybody's going to argue that and have any real leg to stand on. But government needs to step in and say, okay, we've got victims everywhere here. how do we fix it? Not just how do we put the burden on one group of people to the detriment of anybody else. It's ambiguous, and again, it only protects tenants. So those are the three big pieces of legislation. There's also a couple of bills for you, business owners, that will make a workers' compensation claim pretty much mandatory for anybody that gets sick while they're working. Right now, the governor signed an executive order that says there is a presumption that if I get sick, the COVID sickness, while I am working in what has been referred to as an essential business, whatever that might be today, or actually the last half hour, it is presumed that I got sick on the job, and it is now the owner's responsibility to rebut that presumption. There are three bills that are currently pending in the legislature that would make those presumptions irrebuttable. So if I'm working for ABC Construction and I get sick, I'm conclusively presumed to have gotten sick on the job, which means, of course, workers' compensation premiums will probably go on the uptick. A couple of other things, and then we'll talk about, let's see here, we'll see if there's any questions. I don't know, Cody, I don't have any, but I want to talk a little bit about some bad stuff going around, some fraud. And not just fraud, but also some DRE stuff. Stephanie pointed out to me before we went on the air that the Department of Real Estate now has a COVID-19 task force. And I will tell you that there has been, and we'll get more information about this on August the 11th. By the way, Steph, my recollection is you and I are on that panel as well. So I'm pretty excited because I've been wanting to ask this commissioner a couple of questions. So it'll be fun to do. No, they'll be respectful. I promise you that. I might even wear a tie that day. I don't know. But the department has made it pretty clear that if someone does get sick in the property, it is a duty it is a material fact that must be disclosed. Where the argument is right now is how far afield does that duty go, right? Stephanie represents some people that got sick in the property. The property is properly disinfected. What type of a disclosure needs to be made? How far afield are we going to go? Will the legislature create legislation, maybe even another presumption that if you moved into a house, that's where you got sick? Who knows? Or what about conflicting presumptions? I'm working in a job, but then I buy a house where people had the virus and no one disclosed it. And remember, this is a virus. This isn't, the ghost of death that went over Cairo during the biblical days. This is a virus. It's like mold or any other disease. It can be cleaned up. It can be wiped out. But that's really a hot topic right now. I'm going to be attending a meeting. Stephanie, I sent you a letter. I'm going to be attending a meeting on July 30th with June Barlow, who's the attorney for CAR, along with the chief lobbyist and about 10 other lawyers. Just a small group, a Zoom meeting. We do it twice a year just to talk about all these kind of risk management issues. So we'll probably come back on after July 30th, maybe even during that meeting with the department commissioner, and kind of give you guys an update on some of this stuff. Where are we headed from a liability standpoint? Another issue that's been coming up is Cody and I have had a couple of cases. I don't know, Stephanie, if you've had anything where your client actually tells you they're intending to commit an act that's in violation of the contract. In both cases that I've handled with Cody, they were commercial landlord-tenant cases. And in both cases, the city where the property was located did not allow the growing of marijuana commercially. And in both cases, the prospective tenant told the agent that that's what they intended to do. So be careful of that, because you could end up being a co-conspirator in a case. I haven't done criminal law in a very, very long time, since, well before Stephanie was a baby. But I do remember, and I have a granddaughter that's starting law school, that These are issues that you need to be careful of. You cannot participate in misrepresentation. You cannot participate in concealing a lie. And I think that you have that if you're in a situation where you know your client's going to commit a bad deed, you need to be very cautious about how you're going to deal with that. And then lastly, and I think frankly most importantly because it's so prevalent, is Craigslist landlord-tenant fraud. It is really, really serious right now. Lori Smith, who's the professional standards chair, is on top of, not the chair, excuse me, the manager. She's way on top of this. And she sent a couple of articles. I'm going to share some information with Codi. We're going to put together a little be careful do's and don'ts, give it to the association to put on the website. Just be careful because what they're doing is they're taking your rental listings, they're basically stepping in, putting them on Craigslist as if they're their own, unsuspecting people, primarily people, and again, I don't want to stereotype, but primarily people who may not speak English as well as some other people, and or elderly people seem to be the primary victim, although not exclusively. And they're seeing these ads in Craigslist, they're responding to them, they give these people money, sometimes even move in, and then find out no one ever gave them the right to do that. They're out their deposit, et cetera, et cetera. So be careful about, protect your Craigslist. Stephanie, I recall you had a really good idea. I don't know if you remember it or not, I know. I don't know, Stephanie, memory's the first thing to go, followed by memory loss. Oh, no. So, but check your listings periodically. Make sure that if you're on Craigslist or that if your listing gets on Craigslist in some fashion, that you have control of those. Check your properties periodically because it is apparently a really major scam going on right now.
That's a great idea.
Yeah, maybe it was. I thought it was you. It might be somebody else. I represent so many smart people. It's hard to remember who's telling me what to do. But a couple of other things. Showings. Not much has really changed there. Now it might with the governor's new orders. I think we're still an essential business. God, I hope so because the market's red hot out here. I'm excited about putting my house on the market because it's so hot. But it could get chilled real quickly. So here's my point on that. We are an essential business. You guys are. But the governor has not been hesitant at all to change his opinion on things. And if he gets the sense that realtors are not following his rules, even though you may have lots and lots of arguments about those rules, I understand that. You got to follow the showing rules. CAR has produced some incredibly good stuff, and you got to follow it. The PEAD forms have attached to them the PPPs, which are the best practices. You got to follow those best practices. As much difficulty as there is in doing that, if you fail to do it, and I will tell you, and not so much at Pacific West, you guys have been good boys and girls, but I represent 10 boards. And at 10 boards, we're seeing a really wide variety of people that are simply ignoring the rules and conducting open houses, which are absolutely off the table. Not allowed to do that except virtually. And even then, you have some problems. So bottom line, if you're going to show your property, again, control who's seeing it, control the buyers, control who goes in, control how all that's done. Your MLS and your association have great tips. CAR has all kinds of information. Go look. And again, as far as open houses are concerned, same problem we talked about last time. You can't do them, but if you try to circumvent the rules by putting something up that says virtual open house, people are going to stop. They're going to go in. Your seller's not going to know what to do. So you got to control that the best you can. Lori Smith just gave us a little tip. Put something in terms of the Craigslist scam, put something in the window that makes it clear that this is a property that you've got listed and that it is your listing and that they need to contact you so that anybody that goes out and looks at that rental property will know that, well, wait a minute. I just responded to this Craigslist listing, but the actual property says it's listed with somebody else. So I thought that was a great idea, Lori. Thank you very much. Coming soon signs seem to be working pretty well according to the attorneys for CRMLS. So remember, you can put the property on the market for 21 days, so long as you don't conduct any showings. The fine is probably going to be $2,500. Yes, ma'am.
I was going to say there seems to be a little bit of confusion, not with everybody, but with some people. If you're putting a sign up and utilizing the coming soon strategy, make sure it's in the MLS.
The bottom line is this. Let me give you a perfect example. My wife and I are thinking about putting our house on the market. The property is too hot. We've been here for a long time. It's too big, blah, blah, blah. And well, we're not quite ready to do that. There's some loose ends we have to tie up. And so we're gonna allow our realtor to put coming soon. And what that simply means is she can put a sign and put it in the MLS. We will sign a listing agreement. We will agree to do that because she can't do it without a listing agreement. No sign, no listing in the MLS, and there'll be no showings. But because the market is so hot right now, she'll get calls. And the goal being to do what everyone else is hoping to do, is to get people competing for this lovely home. By the way, it's in Canyon Lake. I'll give you, we'll tell you about it some other time. So coming soon signs, you need to understand those rules. It's the C category, if I'm not mistaken, which is coming soon. And then if those of you that are reopening your business, Codi's written some really great stuff. Again, you have to have, each real estate office has to have 2 prevention programs, 1 to reopen and 1 to show property. Okay? And they're a little bit different. CAR has prepared them for you. You're paying dues. You don't need to have your lawyer do all that, although you may want to have him or her look at this stuff. But CAR has done all this work for you, and in my view, they've done an absolutely fantastic job, and they stay on top of it. That's the bottom line. We're all, Stephanie and myself, the board, Phil, your CEO, we're all attending conference calls with CAR on a regular basis, me with the lawyers, Stephanie even sometimes with lawyers, and sometimes with Gov Hutchinson and some others. And we're getting a lot of great information. And the good news is they're getting feedback from people like Stephanie and myself, people that are actually, quote, in the trenches. So it's good stuff. Couple of other issues that have cropped up, and I'm going to just finish with a couple of these things. Number 1, don't forget fair housing. A couple of things we're seeing lately that are a little bit troubling. I got to be real careful about this because I don't want to get anybody upset, and today that means basically using the wrong word somewhere. But what's happening, two areas that seem to be very problematic. One is in either landlord-tenant and or in sale, be prepared to be challenged if you're in a situation with a number of people and that you may get a challenge on fair housing. And it isn't just about color, by the way. It could be about gender orientation. It could be about ethnicity. It could be about a lot of different things. The other thing that we're seeing some trouble with, and I know we've had these conversations before, Stephanie, is with this concept of letters, right? A lot of offices want to write a letter to the seller telling the seller, either from the buyer usually, or the buyer being helped, why they're the best candidate to buy a house, particularly in a multi-offer situation. Got to be careful about that because you could be testing the parameters of some fair housing issues. So be careful about that. An issue that came up just the other day was some free speech stuff. You know, what can I say? Am I allowed now to have an opinion? Well, I do. I just gave it on 1436. But you got to be careful what you say. If you're in some type of a leadership position, you got to really be careful about what you say. Stephanie, it looked like you wanted to say something, and I know it's going to be great.
I was going to go back to the letter scenario, and I know Barbara Betts is on the call right now, and her and I have had multiple conversations about this. And Barb, text me if this is incorrect, but she's even saying like we're not, talking about with the sellers and not presenting any letters that they're receiving and making that known in the MLS, just to avoid any potential, she said yes. That is correct.
Here's the deal, and this is something that came straight from the Department of Fair Housing. You need to be very careful about talking about the characteristics of buyers and sellers. Mm-hmm. Characteristics could be things like color, could be things like sexual orientation, it could be things like disability, it could be family related. There's the only characteristic that your buyers should consider important, frankly, are the characteristics of I can afford this, I'm ready to go, mm-hmm. right? And that came straight from the Department of Fair Housing. A tough issue, I understand that. And it's an expanding issue. Stephanie's been in leadership for a long time, and the poor kid has had to listen to me rant to the board on an annual basis about the fact that I've always felt a couple of years ago that fair housing issues based on where California was headed was going to move to the front of the discussion, and it has. So you need to be very, very cautious about that. I'm not going to have time today to go into teams. I'm going to sit down with Codi. I've written some thoughts on teams and what teams should look like. The fact that you need to have written agreements. You need to have an exit strategy. You need to talk about those kinds of things. We're going to be writing I've written a couple of things the last couple of days that I want to go over with Codi because he's a way better writer than I am. But I have some thoughts on some articles and some bullet points of some things I want to share with everybody, not only about teams, but also about the disclosure of COVID type situations. I've had a couple of cases recently. I don't know, Stephanie, I'm not, as you know, Mr. Technology is not a word that is usually associated with me. That's why last week when Barbara Betts gave me that compliment, I was so excited that I actually came up with a verb in the technical field. But had a couple of cases recently with these Facebook groups. In one situation, a lot of really bad advice was being passed around by realtors. It's one of those things that, where the snowball effect starts. Somebody gives some bad advice, and that bad advice becomes gospel, and then it goes on and on and on. And then the other was, I have a client that really had problems with her client. Client was, to say the least, difficult. We had two transactions. I had to step in. We were able to get both of them closed. But while she was dealing with this particular client, she was telling her Facebook group about what a bad person he was. And he was, in my opinion. Codi, if I recall correctly, opinion is a defense to defamation, because it's only my opinion, right? But the fact is that somehow he was able to get the information that she was bad-mouthing him. So I don't have a problem with Facebook groups. My son-in-law, who works at a company that puts all that stuff together, telling me it's one of the fastest growing areas that you're going to see in the technology field, and that's great. Groups are popping up all over the place. But you got to be careful about those groups, because people tend to think, well, I'm in a little group, I can say whatever I want. You can't. Defamation is still defamation. And frankly, bad advice is still bad advice. And pardon me?
I was going to say, as a broker myself with, a good chunk of agents, it's, don't just, if you have a question or you're unsure of something, go talk to your broker or your manager. Because at the end of the day, if you followed poor advice and you don't know it's poor advice, somebody tells you what they think is correct and it could be the complete opposite. At the end of the day, your broker manager is responsible for you. They're the ones that are going to make sure that you stay out of trouble. So if you have those questions or you're looking for advice on transactions or how something's working, talk to your broker or manager. Don't put your broker or manager in a really poor situation if it hits the fan. So.
And I've got to tell you, I've been doing this for a long time, and I've been fortunate enough to represent realtors and realtor associations and brokers and do risk management for a long time. And it isn't even a question that someone is purposefully misleading you or there's a misunderstanding, and it happens every day. Lawyers do it. I mean, where good brokers do it, where I thought that the law was, or I thought that the practice was, or I thought that the board did this. And then it turns out that something was missing, and so you get a completely wrong picture or a partially incorrect picture, which is a wrong picture. And so be really careful when you're in these groups that if there's a piece of information that's floating around and you're not comfortable with it or you're not sure about it, that you double check and then go back to the group and correct it. And then whatever you do, remember, defamation is defamation, whether it's in a group setting or not. And then I think we're over halfway through the program. So Codi, have we gotten any questions, or can we still yak on and on?
We have one question current, and it's something you can address. I felt like it was a good one for you to talk about.
Okay.
Otherwise, we've been answering some questions. Stephanie's been doing a great job on that as well. Thank you, Stephanie. One thing to note, which was brought up in the question and answer, is the PEAD should be digital, not paper, not showing up, handing it to you, not here, sign on the spot. And that goes, John, we've talked about that before, even with inspectors. Send it to the inspectors in advance. Send it to the appraisers in advance. Get it digital in advance. And so I just want to reiterate that because it seems like that's something that's not being necessarily followed to the T. Similarly, if I may have
Please.
a 2-second rant of my own for a brief moment.
All right.
Just want to remind people.
Finally being formed. Go ahead.
You're teaching me well. I just have this like off switch that disappeared. And so I just wanted to remind people, you mentioned reopening very briefly. You mentioned showing guidelines very briefly. Things are changing every day, and you need to keep looking at that. Even within, I think we got on this call 15 minutes before, and everyone sat down. They're like, okay, great. Did you see all the new stuff today? And it came out within, the last hour, and we were already prepping on old documents or whatever the case may be.
Right.
And the governor dropped all these new guidelines and closed indoors for all these places, gyms, religious facilities, non-essential offices. And so just a reminder to really go back and continue to look at those, continue to just check in on your lunch break, because that's when the governor typically does it. So you're apprised when it comes down.
And I read today there's been, within the workplace itself, there is not unanimity, right? Stephanie, you've got a bunch of people. Some of them may want to come back to work. Some of them may not. Some of them may want to come back to work, but stay away from everybody. You've got to think through that. Obviously your physical location and how big you are and how small you are is going to dictate a lot of that. But you need to be really, really cautious about thinking through all that, because again, remember, the governor has said, and the legislature is going to take it further, that if someone gets sick, it's going to be presumed that they got sick on the job. Now, that's a workers' compensation issue. So the real issue there for most people is going to be, what will premiums look like in a year or two if you've got a lot of employees. But then the other issue is, if there's a presumption floating out there that says if I got sick, it's because I was on the job, what's that going to do with other types of liability? And can the plaintiffs, I'm having lunch on Thursday with a plaintiff's lawyer. He's a good friend of mine, been a great lawyer for a long time, but he's on the dark side of the force. And he's already told me they filed 9 lawsuits at his law firm already. So the plaintiffs' lawyers are out there, and we're going to pick each other's brains because I want to know what's the plaintiffs' bar's theory about how these lawsuits should result in liability. And then he, of course, wants to know why I think he's full of nonsense. And so, but that's one lawyer, but fortunately he's a good guy. He's just on the wrong side of the table. These are big, tough issues right now. And You know, how many of us honestly thought we'd still be having a conversation on July 13th about COVID and shutting down and no baseball and maybe no football and no cruises and no vacations and blah, blah, blah. And I just got back from Tennessee, and I'll tell you, while their governor is not quite as anxious to wield the hammer as our governor is, that's called the volunteer state for a reason. Those people are wearing masks and they're socially, but they're doing it because they want to, because it's the right thing to do, not because the law there is very consistent. Doesn't favor certain groups and things of that nature. So that's a tough spot right now, I think. So I see you got 3 more questions, Cody. So let's see if we can get to those real quickly.
One of the questions is, I saw the pending by the same agent, same company after coming soon for a few days. How does it happen without showing? So you can, I mean, it's the same thing even with COVID. I mean, was it you, John, who you bought your house sight unseen in Tennessee?
I did. So did Ed Zorn.
Yeah.
Again, sight unseen simply means that thanks to all this wonderful technology, I was able to see both there's 3 properties actually. I haven't even seen the one that is being built right now because it won't be ready till March. But the 2 properties that we bought, I never saw until way down the line. And the reason is because I could view them. And I was able to narrow my search to 1031 exchange, and we were able then to go take a look at it. But that's really okay. There's nothing wrong with that. Ed Zorn was mentioning, and I know Stephanie, you and Barbara have been trying to educate me on all the technology. You failed, but you've tried, and I appreciate that, about all this wonderful technology that you guys have to be able to set all that up. Cody made a really great point. Look, if your inspector calls me and says that they've just asked me to sign a document, I'm here at the property now, should I? I'm going to say no, right? But if you send it to them ahead of time, or you tell them ahead of time, this is what is going to be required, and you think through that, read the rules, set it all up, have everything done fairly consistently, I think you're going to be in great shape. All you can do is what you can do. I don't think people are going to be liable. I don't think it's going to be what we call strict liability, where if something happens, you're at fault. I don't think we're going to see that. I think what we're going to see is the level of duty and what is a breach, what is the standard of care. And so by doing things digitally, by making sure you clean the property the same way every time, that by not inviting people to go to houses where there is a digital open house sign or something like that, by putting signs in windows, you're doing as much as you can. And at the end of the day, this is not murder, it's a virus, right? And it can be clean. You had a comment, Stephanie?
Well, I just wanted to clarify with the coming soon. It's your no showings at all. So essentially, the buyer's writing an offer sight unseen, and the seller's okay with that. So it's subject to showing, subject to interior inspection, whatever you want to call it. And that's probably what happened in that instance.
But if the market's, and again, I'm not a realtor, I'm just a lawyer, but if the market's really, really red hot, and you've got a house that that at least ostensibly meets the needs of a buyer, that there's possibility that, again, remember the Code of Ethics and California law require that you present all offers objectively. So if Cody wants to write an offer on a property that Stephanie has in the coming soon category, he's perfectly capable of doing that. It just can't be set up for the showings and all of those kinds of things. So I've been noticing you guys have been putting some stuff up. Somebody have a question? Glenn? Not Glenn Hillier. Forget it. We're not going to answer this question. No, go ahead. What does Glenn want to know?
Yes, we have a question in the chat. They said some inspection companies are signing the PEAD as a company and not actually as the individual who's attending the property. I have a lot to say about that, but I think I'll let you.
No, go ahead. I think we're both going to say the same thing, which is I'll say it short and then you fill in the blanks. No.
Yeah, and that's the best answer. No, that's not acceptable.
No.
It's not a company disclaimer. It's a disclosure and a declaration from the individual signing it. It has to be done within the appropriate time periods, delivered in advance, and it's something you can't just have a blanket signature to for everyone intending a property, whoever that may be.
Right. Okay. So do we answer Glenn's question?
Yeah, I liked the no, though. I thought that was pretty straight and direct.
Okay, good. And no is the answer. You got to tell them no. These are individual signatories. I'm not going to sign on behalf of the Tyler Birch Corporation. I'm signing because I, John Giardinelli, don't have any symptoms. I've been tested. I know I'm good to go. Right? The real issue right now, I think, out there, Codi, and I don't know, Stephanie, if you've had these issues, I've been getting a lot of calls where how far do we go out? You know, I just telling Codi this morning, I have a friend who owns an architectural business. Not a friend, he's a client and a friend, but more a friend. And one of his employees' brother went over to the employee's house, found out he had the virus. Now, how far out do you go? My friend put himself under 14-day quarantine and stayed away from his family, literally. So how far those are the kinds of questions we're starting to see now, and particularly with this uptick. So what other questions have you gotten in? Anything?
Yeah, so someone's asking for clarity about how far in advance can you send the PEAD? I know the lawyer answer to this is it depends, but why don't you go ahead and address that too?
Again, if you've set up and I know, Stephanie, how you guys are setting up showings for people that are going to be allowed to come in, but you want it as recent as possible. You know, you don't want a 2-week-old PEAD form. I would think within the last 24 to 36 hours would be acceptable, but anything beyond that, and again, it's a form. You know, it's a form. Come on, kids. We're not talking about, a 5-hour interview. We're talking about a form. And if you've become familiar with the form, you know what it already says. So get them to sign it.
One thing we're seeing is listing agents requesting an order to set up an appointment, and you're talking like today's Monday. Let's say I want to set up an appointment for Friday. They're saying to send the PEAD over to make the appointment. And I'm telling my agents, okay, that's fine. Go ahead, send over a PEAD, but send over a new one on Friday because a lot can change Monday to Friday. And
I couldn't agree more. I think that's absolutely brilliant. I actually, to me, again, you always have to ask yourself, what's the purpose of something? The purpose of the form is not to fill out a form. The purpose of the form is to make a statement via a declaration. I'm coming into your house and I'm good. And I'm assuring you that me and those little kids that I'm bringing in with me, we're all good. My wife is signing her own and she's good, right? And that's really the purpose, is to basically make a representation to the prospective seller that the people coming into their property don't have the symptoms, the virus, this and that. And it's the same for all the other PEAD forms. It's simply a representation. Unfortunately, because of all the legalities, CA are hard to do it on 2 pages. It's actually 10 pages if you also attach the BPPP. But the reality is that the actual declaration is 2 pages, if I recall correctly. So.
And the BPPP has now been reduced, and it's only 2 pages.
Okay. Well, you can tell I've been gone. That's good news. That's right. You told me, Codi, the other day that they updated it again. So good. Okay. Got a couple other questions here. What's going on?
Yeah. So let's just move down the list. Is there someone's asking a question about ADU specific forms? If there's one that they should be using when buying or selling a property. I actually have not came across that yet. I don't deal with a lot of ADUs. Have you, John? Or
I know they're actually going to be a lot more down the road if we get back to these laws that are allowing for construction. But no, I'm not aware. Are you, Stephanie, of any? I know there's a CAR is going to be doing a webinar on ADUs, or they've already done it and now it's been recorded and is available. But I've not seen a form specific to that issue. Most of the stuff that you would need if there is some type of accessory dwelling unit, is going to be in the right form. If you use the correct form, you should have what you need, and then of course any additional information can be provided.
Would you, and not like if there is an ADU, there's no specific ADU forms, but would you fill out like a separate TDS and SPQ for that person?
Actually, the way the TDS is written and the SPQ, it does include, if I recall correctly, those types of situations. But again, what are we trying to do here? We're trying to provide, if it's, I just finished a situation where there were 4 units on one lot, right? And in that case, yeah, you want to go to each unit, and whether you do it separately or make it a combo, you need to be specific as to which unit you're talking about, right? If I have in Hawaii, we call them ohanas, and here they're called, I don't know, granny flats, and they're all called different things, but if there's an additional residential unit, I don't think it's a bad idea, Stephanie, that you do a separate TDS or SPQ. I don't know that it's required legally, but certainly the goal is what? To make disclosures so the buyer has all the information that the buyer is going to need in order to make a good decision, right? It's no caveat emptor, no buyer beware. So however you should do that is going to be dependent upon your transaction. But again, these are risk management issues. If you want to manage your risk, do as much as you can to get the buyer as much information as they possibly need. Lori just came back.
And in fact, we just did that. I was helping another attorney in our firm. We were helping with a commercial sale, just kind of advising on it. And they had numerous residential properties that were on this larger piece of property. And we did a TDS regional. And then we just thought that was the best way to do it, is just to break it down. And I would probably advise the same given the circumstances of an ADU. Just do another one.
Yeah.
For it.
Again, don't worry about forms, worry about disclosure.
Right.
Again, go to the heart of the matter. The purpose of the law is not to fill out a form. The purpose of the law is to provide a buyer with all the information the seller has. And sometimes that's very difficult. My wife and I have lived in this house for 36 years. There's a question on the seller property questionnaire. Have you ever made any repairs? Well, my God, my wife has remodeled this house on, numerous occasions. And so how we're going to do that is actually going to be a strategy discussion, right? We'll sit down with our realtor and we'll figure out from a strategy standpoint how we're going to make disclosures. Because the have you ever it can be a very difficult question to answer. So what else do we have out here? Got a bunch of questions, looks like about 8 or 9 of them.
Looks like we have, so one of these is, can an agent, this one's interesting, and this is actually something you could probably rant on. Can an agent with an expired license, which that's a problem in of itself, an agent with an expired license send you a PEAD with the information probably whited out in the bottom right-hand corner? And I know I see these all the time, so I'll let you answer it, John.
Well, here's the problem. Stephanie, this is the fun question. Okay, so the agent is violating the law. And at the end of the day, the agent is not entitled to a commission because he's an unlicensed or she's unlicensed. However, you have a duty to your client to present all offers and to discuss everything objectively, right? So as far as the PDAD form is concerned, the fact that I'm whiting out and again, in my world, before I understood how computers worked, I had whiteout all over my screen. But from the standpoint of the purpose of the form, it's that former realtor is telling you, I don't have the disease, right? And so what you need to do, Stephanie, I really would look to you, but I would sit down with my broker and then with my client and say, we've gotten in some paperwork, probably maybe related to a potential offer, but we have found out that the person does not have a license. Maybe what happens is, Stephanie, you call the broker and say, are you aware that Bob Smith is making offers and that Bob Smith is not licensed right now? Because again, that goes that's a broker supervision issue at the core. So the form itself can be filled out. It's the issue is dealing with unlicensed people, and that's pre-COVID. I mean, we've been doing that for years, right? So I just think you need to be very careful. But that person is technically committing a crime, and does not have to be paid. So what else we got here?
Let me see. So there's a question from Philip Yates. It's a little off topic. Basically, he's asking, is there a CAR recommended form for ESA rules in rentals? And he gives an example. So thank you, Philip, for the example. If a tenant submits a reasonable accommodation request form that is approved, what do we do to establish the rules for the ESA?
For the what?
ESA.
I'm drawing a blank.
I think it's he's asking for the accommodation, if I understand right. Is that correct, Stephanie? Is that your understanding as well? Or Philip, if you could clarify on the emotional support animal, there it is.
So basically I need an accommodation of some sort. Maybe it's wheelchair, maybe it's lowering the cabinets, maybe it's a companion animal.
Right.
We've worked out our reasonable accommodation. How do we document that?
Yep.
I'm not aware of any form for that. It's a great question to send to the Department of Fair Housing, is that's a great question, actually.
Yeah.
How do I document a reasonable accommodation? Number one, remember that the party is entitled to their privacy. So if you're going to document it, you're documenting it solely into the file and solely with your owner, and that you're protecting the privacy, the confidentiality of that person, and then document it the best way you can. You know, dear Mr. Smith, with my seller's permission, we're hereby agreeing that you can bring in a companion animal, or that we will allow you, subject to proper permits, to lower the cabinets, or we'll allow you, subject to proper permits, to build a ramp, whatever it is, and add to that probably that we've agreed that upon your termination of tenancy, we will be allowed to, you'll pay for the returning the property to its correct proper position. Right. If it's a situation with an animal, you know, just document it. It doesn't have to be long. It can be short and sweet. Now, I'm not aware of a form for that. Maybe there is one. I'm certainly not aware of it. But it certainly wouldn't hurt to check with the Apartment Owners Association and or with your lawyer and have them create something. I'm not aware of a particular form.
Yeah, I'm not either. And it's someone commented in the chat box, and I don't know whether it's a typo or I think it's funny nevertheless. They said the Department of Fair Housing has internal documents that they can use with employers as they understand it. So it's possible. I don't know of any documentations that the Fair Housing Department has, but perhaps check there, as someone has indicated.
I can send an email over to Brandon,
yeah, and
see if he can tell me if there's anything. I'm not aware of any forms. I've not found the department to be particularly helpful to landlords or to employers. But I may be wrong. There may be something internally. I've never personally seen one. I just know you got to be real careful about documenting these things and protecting the privacy of the person that's being granted the accommodation. Okay. Anything else?
Expanding slightly on that, I'll give you the last question we have in here, at least for now, and I'll kind of rephrase it. When you have an emotional support animal in the home, Philip is asking, what kind of rules can we put on that, essentially? And that's an interesting one, because I think when we talked with the Department of Fair Housing a couple weeks ago, it was really important to distinguish that these are not pets. It's not that you can, put necessarily the same restrictions as you would with a pet coming into the property. And so I don't know exactly what he's thinking about as far as his.
I can tell you what Brandon and I talked about, the lawyer for the DFEH.
Right.
What you can do, what you cannot do, is create a separate deposit, because deposit, this is not a pet. Number two, so you can't add more money. You cannot put on unreasonable rules and regulations because they're not pets. By law, in writing, they're not pets. However, you also have a duty to protect other tenants and the property. So you can require that the owner control the animal. No barking at 3 o'clock in the morning, dog on a leash, cleaning up messes, no mess in the house. Those are perfectly reasonable rules. Because remember, the rule, again, let's look beyond the rule and let's look at the purpose. It is a reasonable accommodation. Now, the word reasonable is obviously ambiguous, case by case, but it is reasonable under the circumstances, favoring the tenant over the landlord, but it doesn't mean it's carte blanche, right? You can require that the animal, if local jurisdiction requires it, be properly licensed, be properly coded if there's a chip requirement. All of that stuff is perfectly acceptable, perfectly acceptable. Put it in writing, you can put it in the form. What you cannot do is add burdens that are not related to the characteristic. In this case, because the person needs a companion animal to overcome probably some type of an anxiety disorder, okay? Therefore, the characteristic is the anxiety, and the treatment is partially the animal. So what are the characteristics of the animal? It's not more money, right? It's not limited access to places. It is noise. It is cleanup, right? All those kinds of things go into a reasonable accommodation. So I think that, and again, there's lots being written about it. CAR has a great Q&A on pets and animals and companion animals and all that. You guys all pay for this stuff. Go to the CAR site and look it up. If you want us to write a newsletter, we'll be happy to do it. Let Stephanie or the board know, or send Cody or I an email. We'll be happy to expand on these issues. Happy to do it. Okay, is that it? We're done?
Just one more reminder, Lori brought this up to remind everybody. She's getting a lot of questions in regards to door dropping or door knocking, door marketing, whatever you want to call it, all of the above. Still, no, don't be knocking on people's doors during these times. Don't be handing out flyers or postcards, and just don't. Not a good idea.
I've been actually because I was in Tennessee, and since we had to pick interiors for the new house, that of course meant I had very little to do, and so I was doing a lot of catching up on a lot of reading, and there's been a lot of talk in your industry about how we're never going to go back to the old way of doing things. That if you're not privy to all the technological changes, to technological advertising, social media, all that, it's going to be a long time before you see the kind of stuff Stephanie's just talking about. Because it can technically transmit the illness, it's not a good idea to use that kind of stuff, right? And so just got to be careful. A lot of this stuff is basic common sense. You think of being, we've been under house arrest now for 4 months. We've ought to develop some common sense. And don't make it more difficult than it is. And don't fight it. A lot of us, me included, think a lot of these rules are selective, unfair. The governor's picking winners and losers. We all know that. Some of it's politically motivated. We understand that. But the plaintiff's bar doesn't care. When it comes time to start suing people, they're going to go to what the law was. And if you didn't follow it, you're going to be in trouble. Simple as that. Whether we like it or not, I'm not going to give you the comment I really would like to give you. But, government's very powerful right now, and that's the way it is. So be careful. And if it may change, it may not, it may get worse, So the bottom line is that you've got a lot to lose by not following the rules. So follow them. And before you can follow them, you've got to read them. And then if you have questions, the board has done a bang-up job. CAR has done a bang-up job. I mean, the stuff they're giving all of us who are trying to help you guys has been just phenomenal. So take advantage of it. Well, it's 2 o'clock. I ranted long enough. There's a good Hallmark movie coming on at 3:30. So anyway, if there's stuff that you want to hear about, again, it isn't just about me. Stephanie's got all kinds of access. Lori's got all kinds of stuff. If you want Codi to write something about a subject, just let us know, right? The board's been incredibly responsive to all of your needs. And so, but there may be something we're missing simply because we're not talking to you all the time. So let us know what you guys want, and we'll do everything we can to get it to you. So Stephanie, would you like to say goodbye to everybody since you're the boss?
Goodbye, everybody. Thanks for being here. Thank you for being here. John brought it up a little bit ago. CAR has done a fantastic job in keeping everybody up to date. If you have any questions, that's a great first place to go. CAR, they've got lots of guidelines, what you can and can't do, and they're updating those as needed. And they did just make an update today in regards to open houses, so please check that out. Go to I think it's CAR.org/ just go to CAR COVID updates and you'll find it. That makes sense.
I cannot go offline without mentioning somebody that hasn't been mentioned today. And I can't pronounce her last name, so I'm not going to try. But your government affairs director, Christine, has just done a bang-up job. I mean, I can't even say in the right words what a great job she's doing. Not just keeping the board up to date, but Codi and I on all the legislative stuff, and also you guys. So she puts stuff out as needed as well, and she is just a phenomenal source of information, one of the best out there. So keep an eye out. How do you pronounce her last name?
Christine Schechter.
Schechter. Okay.
Schechter.
So Goedl and Giardinelli say go to Schechter, and I just think that you will be very happy you did. She's been really just killing it, and so keep an eye on what she's writing as well. And Lori, you too. You've been doing a phenomenal job keeping the membership up to date, and the Code of Ethics issues, which are basis for California real estate law. So you got one-stop shop there, kids. So use it. All right. Have a good one. Codi, I'll talk to you tomorrow morning, I guess. Lori, I'll give you a call later. Okay. Thanks, Steph. Appreciate you
everyone.
participating today. Bye-bye.
Bye-bye.